All right, I think we're going to start now. Good morning. As I said, this is Mitch Tanenbaum. I am a partner with the cybersecurity consulting firm CyberCecurity. Dan Nelson, partner at the law firm Armstrong. Teasdale is also going to be a co-presenter with us today, and I'm going to ask Dan to introduce himself here in a second. Today, we're going to talk about California Assembly Bill 375. Now, in theory, the Senate bill affects people who live in California, but really every company who does business online more than likely does business with California residents, and that's really the defining component of this. So we're talking about protecting the personally identifiable information. This is very distinct from many laws which protect non-public personal information. This really does not have a non-public component at all. This is just personally identifiable information of California residents. So Dan, please do an introduction, and then Dan and I are going to go back and forth between the slides, and we'll probably jump in on each other's slides as well. So Dan?
Good morning. Thank you so much for joining. I know Mitch and I always enjoy talking about these issues with folks. Mitch mentioned I'm a partner at Armstrong Teasdale. I co-locate in the firm's Denver and St. Louis offices. I'm co-lead of our firm's privacy and data security group. I'm also a certified information privacy professional and a certified ethical hacker.
And my background includes being the Chief Information Security Officer for Texas Insurance Defense Systems, and being the Chief Technical Officer and Chief Information Officer at a couple of financial services firms. So I've been doing this for more years than I really want to admit. So recently, Kristen Nielsen, who is the Secretary of Homeland Security, did a speech at George Washington University and made this rather impressive quote, which I certainly agree with, that cyber weapons and sophisticated hacking pose a greater threat to the United States than the risk of physical attacks. One of the reasons why this is the case is that the opportunity for rogue individuals who are not directly aligned with a particular nation state to go do an attack and be very successful in an attack is a whole lot easier. We see that in a lot of the attacks. This is why organizations really need to go off and up their game when it comes to cybersecurity, and why we're seeing the laws really amping up in terms of what the laws protect. So this bill has an interesting background in terms of how it came to be. There's a gentleman named Alistair McTaggart, who is a real estate developer based in California, who self-funded a ballot initiative that would have implemented an even tougher law than this law turned out to be. The legislature decided that they were going to go off and pass a bill, and this particular bill, even though there was a lot of whining about how this bill came about in a matter of about a week, which it did in some respects, it really was introduced back in 2017 and really never went anywhere in the legislature. So the problem was that if they allowed the ballot measure to go through, it was very, very difficult for the legislature to change it after the fact. And as a result of that, they said, okay, well, we'll pass a bill. That way we can go change it whenever we want. And we've seen, we'll talk about later, that they've already made some minor changes. With that, let's see here. I think Dan will talk about who does the law protect and how does that work?
Yeah, and I want to emphasize that in many respects, this bill, I won't say it's explicitly modeled after, but it's going to, provisions of this are going to sound fairly familiar to a number of the listeners, because there are some definite parallels to the General Data Protection Regulation, GDPR, which was passed in the European Union and which went into effect in May of 2018. So to the extent your organization has been dealing with GDPR compliance and looking at GDPR issues, there are going to be some similarities you're going to see. Not exact parallels, but certainly some similarities. One of those, I think, is the broad scope of who this bill covers. And it doesn't just cover customers. It doesn't just cover individuals with whom you may transact or prospectively transact business. Rather, it's got a broad scope of coverage applying to all California residents. So that's your customers, but that's also employees. It's also physical visitors to your buildings, virtual visitors to your website or other internet presence, contractors, independent contractors, vendors. This really, anytime you are physically or virtually touching a California resident, you are likely, you need to at least be concerned about, and are likely within the coverage of this bill. Mitch?
I think that's really a huge, we're starting to see more and more of this. The Colorado law, for example, that just went into effect, this law has some exemptions for really small businesses. The Colorado law doesn't have any exemptions for anybody. We're starting to see a much broader definition of who's included.
And again, so we talked about who does the law cover from the standpoint of who does the law protect, who's subject to the law. And as many of you who have dealt at all in the area of privacy, or if you've had, unfortunately, a data incident, a data breach, may already know, in the U.S., rather than having sort of omnibus federal laws which apply across the land, we have a patchwork of state laws. But a feature of most of these state laws is they don't make the applicability to the law. They don't tie that to a physical location of the business or the state of incorporation of the business. Rather, they protect their residents. And if your business is transacting or is holding the data of those residents, then even if you don't physically enter California, you are still subject to the California law. So although this is a California law, its application really is nationwide and, in fact, even international. So unless you make a conscious decision not to transact business with and not to have contact with, I think California is the world's 5th largest economy. Unless you decide to forego all contact with things California, you are likely subject to this law. Now, there are some carve-outs essentially designed to make sure that the burdens of compliance don't fall on small or very small business. So if you have annual gross revenues under $25 million and you don't annually buy, receive, sell, or share the personal information of 50,000 or more California residents, and you don't derive more than 50% of your annual revenue from selling consumers' personal information. If you meet all three of those tests, then despite the fact that you are coming into contact with California personal information, you wouldn't be subject to this law. That's not going to carve out a lot of people. Those are fairly limited carve-outs, but those carve-outs do exist. One thing I want to point out is that the second bullet on your screen, annually buy, receive, sell, or share, don't focus too heavily on just the buy or sell components of that definition. Rather, look at the receive. So, for example, if your website is obtaining this information, even if you're not buying or selling it, that still counts. You're still within the ambit of the law in terms of the 50,000. Likewise, if you are sharing information. So the law is much broader than just simply buy or sell the information. One other thing, if you look at the second bullet point, I'd like to point out, it also includes information shared by devices. So an increasing number of our clients, an increasing number of people in the digital economy are involved somehow in the device side of the economy, whether you're smart meters or Fitbits or whatever it may happen to be. So if those devices are purchased by California residents and therefore you are in the data stream for California resident data coming from those devices, that counts towards this 50,000 total. Mitch?
Yeah, and I think that's the one that's going to catch the most people. So if you think about your typical family, and let's say you have a Netflix account and you have 2 parents and 2 kids, well, that one family counts as 4 under this 50,000, not just 1.
And to that point, I think frankly it's going to be hard for a lot of companies, even if they're smaller in terms of size of revenue, things like that. That 50,000, that the number of individuals whose information you may have, it adds up in a big hurry. The law also broadens its coverage in some other ways. First off, you can't get around the law by directing others to collect the information on your behalf. So if you are kind of going to the GDPR concepts of controller and processor, if you are directing the collection or sharing of this information, even though it's by an independent contractor, even though it's by a subsidiary, you're still covered and subject to this law. So you can't get around it by the quick shortcut of hiring somebody else to do it. Second of all, and the nuances of this are beyond the scope of today's call, but in looking at whether you're subject to the law, you also need to look at controlled affiliates. So they're looking at family groupings in terms of determining who the law applies to. Again, you can't create an affiliate that simply collects this information and try to keep that at arm's length and say, well, the rest of the organization is not subject to this law. And then also companies which share common branding. So if you have one or more corporate entities, but they're under the same brand umbrella, they are aggregated for purposes of determining the applicability of this law. The short takeaway is that the legislature, the lawmakers, as have many lawmakers and regulators, have looked at what's happened over the last 15 years in the privacy field, and they have built in some provisions which take away some of the shortcuts that people had traditionally or originally taken to get around compliance with various privacy laws. Mitch?
When you talk about the directing others, think about all of the different cloud service providers that you as an organization use, whether it's an Amazon or a Salesforce or whatever it might be. You know, those all fit into that number.
So what types of information does the law apply to? And again, this is an area where I think if you're familiar with GDPR compliance, you're going to see some similarities. It is a lot broader. It is substantially broader than what we're used to, for example, in the data breach area. And I'll get to that in a second. It's the personal information of California residents, and it is both online and offline, so physical world, hard copy information that is covered. Mitch?
Nope, I think I'm good.
And as I alluded to a moment ago, it's much broader than the typical definition of personally identifiable information, which many of us might be familiar with from state data breach statutes. Now, of course, those state data breach statutes themselves are not 100% consistent. Some are only names and socials and government IDs and financial and a few categories like that. Some broaden it to include healthcare. Some broaden it to include biometric. Colorado's new law broadens it to include usernames and passwords. But the definition of personally identifiable information that you may be used to working with from the standpoint of data breach laws, put that out of your head and think much, much more broadly than that when you're thinking about the types of information that are covered by the California law. And it basically is any information that could identify an individual or be used in conjunction with other information to identify an individual. In other words, the information that you hold may not in and of itself identify, for example, me, but if it could be mixed with other information to identify me, then it is within the coverage of the law. You just have to think very broadly. We're going to go through some examples here in just a second.
Yeah, I mean, it's really an incredibly broad definition of personal information.
So information that identifies, relates to, describes, capable of being associated with or reason or indirectly with the consumer or household. Again, the online advertising industry, the data broker industry has become exceptionally good at taking bits of information which in and of themselves don't identify anybody aggregating those and developing remarkably accurate targeted identification of an individual by these disparate bits of information. This law is designed to regulate those disparate bits of information just as much as it's designed to regulate specifically identifying information. Mitch?
And we're going to talk about some very specific details here in the next couple of slides.
So we have identifiers. This one would probably not surprise anybody in the terms of names, postal addresses, other personal identifiers, email security numbers. A lot of those are fairly common from our personally identifiable information in the data breach context. But we do also have online identifier IP addresses, saying that information that's being acquired in the background, cookies or other tracking technologies attached to websites, that is being pulled in, as well as characteristics of protected classifications under California or federal law. Some other examples, Mitch?
So we have more here, and Dan will go into it, but this goes on for a number of pages.
Sure. So we have commercial information, which includes personal property records of business transactions, product or service, consumption histories, biometric information, internet or other electronic network activity information. So again, don't think just narrowly in terms of, if you think about your privacy policy, you probably have a privacy policy that says there's information we collect when you voluntarily provide it for us, for example, by registering for a newsletter or signing into our page. And then your privacy policy probably talks about information that is collected in the background. That information collected in the background is likely just as much subject to this law. Next, please. Some other interesting categories: geolocation data. So if you, particularly on the device side, if you are collecting geolocation data, that data is subject to this law. Even things as interestingly as olfactory data may be subject to this law. Employment-related information, and then also education information. And in this respect, the law attempts to dovetail with and pull definitional strength from FERPA, the Family Educational Rights and Privacy Act, the federal act that protects records, educational records. And it also, again, protects inferences drawn from the information otherwise defined in the specific definitions. So this is not a law that you can easily think about loopholes and ways to get around from the standpoint of trying to craft very careful buckets of information you collect. It is a broad-based law. If you're collecting information of or about California residents, you need to be concerned about this law. And finally, there are some limited exemptions from the definition of personal information. Information which is publicly available from various government records, so long as used in a manner consistent with the purpose for which it was collected. So if, let's take a land record, a real ownership of real estate record, if you're using that, collecting that information, and you're using it in the context of real estate transactions, then it could be an exemption from the law. If you're taking that information and using it for purposes in the context of real estate transactions, for example, you're going to add it into a marketing database to sell some other type of non-real estate related service, you're beyond the report to directly reach, and that would be primarily some of the things that are at the core of regulation. Make sure there's not example in this law.
So now we have a kind of a sense here of the incredibly broad definition. What rights does this law confer on people? And we're going to talk in some level of detail, but at a high level, the right to know what information people collect, the right to limit the purpose for which the data is used, the right to request that the data be deleted, the right to opt out of sale, and there's even some caveats of that which says that you're not allowed to discriminate at people. Well, I guess that's the next one. You can't discriminate against someone because they executed one of these rights. There's regulatory enforcement associated with it, and a somewhat limited right of action. The limited right of action is one of the big differences between the ballot initiative that was proposed and this particular bill. Dan, anything you want to add to that?
No.
Okay, so let's talk about the right to know. This is similar to the rights that people have under GDPR. So a company needs to be able to provide consumers with what information the company has collected about the consumer, the purpose for which it was collected, where the company got the information, how long that information is being used, whether the information is being sold or disclosed, and to whom. Now, important distinction here, and a little bit of muddiness in the law, and we will see as the lawsuits continue, is whether or not information that you collected about somebody from a third party is covered here or not. It also does limit the data to the data that you collected in the last 12 months. So you don't have to go off and provide people with data that you collected 5 years ago. Dan, any thoughts?
I think that the one key component of this is looking at, and we'll talk about this a little more depth later, but this obviously puts a significant amount of compliance obligations on people. So I think looking at the breadth of not just what information you must account for, but all of the ancillary sort of the metadata on the information in a philosophical sense, not in maybe a technical sense, but all the information about the information that you need to be collecting. That's an important note to make. Mitch?
And I think the challenge you've got is, in order to be able to do this, in order to be able to provide this, and you have to do it within a narrow window of 45 days, you have to know what data you have and where it lives. So does it live on somebody's workstation? Does it live in the cloud at a third-party service provider? So that becomes some interesting challenges. One of the other challenges is the issue here of when you have to inform consumers, and what the law says is at or before the point of collection. So, if someone logs onto your website and they fill out a form, well, that's pretty straightforward, right? Because you can do that at the point of collection. What if you're getting this data from a third party and we haven't sorted out the muddiness in terms of whether that data is covered or not? Then you may not even know what data from what consumers you're getting at the point of collection. And even if someone is, let me give you an example. What happens if you are applying for a mortgage loan and you go off and provide information to the mortgage lender in terms of information about the borrowers? So not only do you have the person who is logged onto your website, but probably a co-borrower, for example. Well, now, how do you inform that co-borrower when the co-borrower isn't even logged onto your website? And you don't even know until you receive that. So it's an interesting challenge. That's probably something that'll get cleared up in court. But at this point, it's a bit muddy. The interesting challenge is going to be this whole issue of the law calls what they call a verifiable consumer request. Now, they don't define that, and one of the good things in this law is it does require the Attorney General to create implementing regulations. But how exactly do you verify that a consumer is Mitch Tanenbaum? How do you know that Mitch is Mitch, and how do you know that Mitch is the Mitch Tanenbaum that you have data on? The law doesn't go into any detail at all in terms of how you define the verification procedures. So you better be able to defend what you're doing in court. Dan?
Yeah, and I think that the point about the California Attorney General and the implementing regulations is interesting in two respects. Number one, we've already heard a report back from the California Attorney General that they're going to need more resources in order to write those implementing regulations. They've already made that request back to the legislature. So We don't expect these regulations to be available in the near term. Obviously, those regulations will put a lot more gloss on some of these points. Questionable how much additional clarity it will put on some of these points. But again, this is still very much a law that's in a state of development. I think fundamental points are going to carry through, but there is going to be much to track and learn as we watch over the next year to 18 months.
So one of the things that could wind up being is, maybe this is a whole new cottage industry for hackers. If a hacker can go off and let's say, and we see this all the time, well, if you know the last 4 digits of my social security number and my zip code, well, surely that must be me. No one could possibly know that. So if a hacker goes off and figures out, organizations that have a weak verification process and use that process to actually go off and steal data on California consumers, the net effect of that is a weaker set of protections for consumers, not a stronger set of protections. So that's going to be an interesting thing. Dan?
I think that companies are going to have to be very thoughtful about how they derive their verification scheme. We may get some guidance in the regulations when they do come out from the implementing regulations from California Attorney General. Barring that, companies are going to have to put some thought into what verification mechanism they're going to provide in order to try to provide something that's got a degree of security to it.
So, as I said, this creates some interesting challenges. The first one of which is you have to know where your data is. How it gets collected, where it gets collected, by whom, where it's stored, when it gets deleted. Do you have a data retention policy? If you have told people, and we'll talk about this in a minute, but if you've told people that you're going to go off and use it for a particular purpose, like for example, let's say I am using it, I'm Amazon and I'm using it to fulfill an order. Does that mean that I can go off and share that with third parties? Not if I didn't disclose that. No. Does it mean I can use it for marketing other services that are not related? No, I think that's that either. So it's going to be interesting. They also are going to have to create policies and procedures and compliance mechanisms for how would they share this data with third parties, whether it's a sharing mechanism, whether it's a sale mechanism, whatever it is. And we have clients who use third-party service providers, like, for example, a print shop to do direct mail. How do you make sure that they do not do anything that is inconsistent with your collection disclosures? And we've already seen issues with that with some of our other clients. And then how do you manage to track that you have, in fact, met the compliance requirements when a consumer does make a request? Dan?
Yeah, I think that, I'm going to go back to the very first bullet point because this is sort of a soapbox of mine. And some of you may have undergone a formal data mapping, data inventory exercise. Perhaps in conjunction with GDPR, perhaps in conjunction with other operational requirements. If you have, good for you. And I'm sure that if we took a poll, we'd have 100% of you that have gone through that process that would have said, yes, we found data in surprising places. We thought we knew where our data was, but we didn't know where all of it was. For anybody who has not undergone a formal process, I will guarantee you that data exists in repositories and in channels that you will shock and surprise you. It is just simply inevitable. Information tends to flow all over the place, and you will be very surprised at some of the locations, some of the people touching your data, some of the people using your data, some of the ways it's used, and some of the places it's being transmitted and stored that you didn't really have any idea about. So I think at the heart of GDPR, in my view, in the heart of this compliance with this law, in my view, is really getting a formalized handle on where your data is.
Yeah, actually, I completely agree with everything that Dan just said. We have a client who just hired a full-time person whose only job is to go off and manage the inventory of data. And they're in a data-intense industry, but still, that is her only job. So when it comes to purpose limitation, the law says that it must generally be used for company's operational purposes or other purposes that you told people about, and that are reasonably necessary and proportionate to the purpose for which the data is collected. Now, hopefully, the Attorney General provides some guidance on this, because this is, pretty loose. You could probably interpret this in a bunch of different ways, but you certainly can't use it for a purpose that wasn't disclosed. And then if you do want to use it later, you're going to have to go get an additional disclosure. And then obviously you can't collect information if you did not provide notice. Dan?
I've got nothing else on this one.
All right. So the right to deletion, again, like GDPR, people have the right to have their data deleted upon request, but there's a bunch of carve-outs. The business can refuse to delete the data under a number of circumstances, which I will go into. But when it's necessary for the business to do the things that the business needs to do, or do the things the consumer has asked the business to do. Dan?
I'll wait my comments until after your example.
Okay. So in the examples here, we have, let's assume that you have, as a consumer, asked the business to do some sort of transaction, or reasonably anticipate that. Or, as a business, you need to log people's access to the website or other online resources in order to prevent or track or prosecute illegal security activities. Or you need to debug software. And certainly free speech, which is going to be an interesting challenge even in all by itself. So those are going to be things that we're going to see that organizations have, and there's actually some more that we'll talk about too. So in certain kinds of limited research, internal uses that are reasonably aligned with the expectations of the consumer, that are necessary in order for you to comply with a legal obligation, or some other manner that's compatible with the context in which the consumer provided the information. Now, one of the biggest challenges I think that organizations are going to have is getting their employees to understand that. Think about a salesperson. Now, I've never met a salesperson who didn't find a piece of information useful. They probably don't know what it's going to be useful for, but by God, it's useful. And those are the ones that are really kind of scary, because you're still going to be responsible for those employees, even if they go off and do something that you didn't tell them was okay. So employee training is going to become, policies and procedures and training is going to become a big component of this. And that also applies to third-party service providers that you share data with. So just because you went off and handed that off to somebody else doesn't mean that I'm not going to keep it, but they're going to keep it. And the third-party service provider could wind up being liable as well. So Dan, I think we're out of this section if you have your thoughts on it now.
Yeah, and I want to just emphasize that this right to deletion is significant. There are these exemptions, but I think, as Mitch touched upon, and as I want to expand upon a little bit, these, in my view, are not the type of exemptions one wants to attempt to take advantage of on an ad hoc basis. I think that part of compliance with this law is to look at the right to delete, look at your data inventory, and then look at what exemptions or what circumstances you might believe you don't have to delete, and to develop a policy, procedure, and then user education as to how you, as an organization, within your own organizational context, are going to invoke those exemptions. This is not something to just sort of wait and see on, and as requests come in, to start trying to ad hoc work with legal or work with others in the organization or outside the organization and say, well, how are we going to treat this one? How are we going to treat that one? We really do need to implement this thought process up front.
And I think it ultimately boiled down to, can we defend the decision that we made in court if we have to defend it? That's the ultimate guideline. You may not win, but at least you have a reasonable argument. So the next right is the right to opt out of sale, which means that I can say no, that I do not want you to share this data or sell this data with third parties. One of the things that's interesting is the law very specifically says you got to have 6 words on your, they don't call it a website, your online presence. On the home page, it says, do not sell my personal information. And if you click on that, it's that got to take you to a page where you can go off and state your preferences with regard to that. So in theory, although I don't think this is ever going to happen, you know, if you phrase the sentence differently, you are technically in violation of the law. And you have a right to equal service and price with one particular caveat we'll talk about in a minute, even if I exercise my right to not have you sell my data. So if your business model is based on the fact that I'm going to sell your data, you know, think of Google, and people opt out of that, you know, you can't charge them more, you can't limit the service, and you can't penalize them for exercising those rights. Dan?
Yeah, I think that it's not on the slide, but the law is pretty clear in terms of how you have to make consumers aware of and give consumers the residents the ability to exercise their do not sell my personal information rights. And I think this is probably a reaction to some of the creative draftsmanship that we've seen in the past few years, where companies are very creative about ways of maybe in some people's view obfuscating rights. The law doesn't give you a lot of wiggle room in terms of how to make this right available to consumers.
So remember, we keep using the word consumers, but go back to what Dan said originally earlier in the presentation in terms of who this applies to. This is, you know, employees and vendors and visitors, and so it's not just consumers.
Yeah, thank you, Mitch. You're right.
So one of the interesting challenges you have is that a business, according to the law, cannot require a consumer to create an online account to obtain a copy of their data. So let's assume that someone exercises their right to go get a copy of their data. Then exactly how do you do that? Then it may mean that you have to mail the data to the person, and it must be done in a usable and portable format, because they want you to be able to give that data to a third party, which could be, by the way, your competitor. That's part of the design of the law. You know, if you have your Gmail account and you want to be able to go to, God forbid, Yahoo Mail, then you know, they have to be able to give you that in a usable and portable format. So are you going to mail a flash drive? So again, hopefully some of this will get clarified in the implementing regulations. But you know, if you have large quantities, one of the things, for example, that they talk about is, you know, if you run a call center and you record calls coming into the call center, is that recorded call part of the information you've collected from the consumer? And if so, how do you even get that out of your call recording system? How do you even inventory that happened? Do you know that you did, in fact, record, say, 3 different phone calls with this consumer on different dates? Dan?
Go ahead.
So next right is the right, and we've kind of touched on this, the right to be free of discrimination, but they call that out specifically. And it says that you have to provide equal service and pricing regardless of whether they opt out or not. Now, what they discovered before this legislation was passed was that technically made things like loyalty card programs illegal, because in that case, you were giving people a benefit for giving you more information, and it said, well, that's not equal service. So they did do a carve out for things like loyalty programs and things like that, so that those did not become illegal. Dan?
And I think this is an area of the law that's going to look at some, one of the areas of the law is going to have some further definition provided either by regulation or ultimately by court interpretation. But the fundamental point is that recognizing that this information, this personal information, has a value, if the business is willing to compensate the resident for that additional value, and the resident is able to receive that and sort of freely give up some of these rights for value being a relative term in terms of the types of things that might constitute value, then that transaction can go forward. But it's really putting into much more discrete channels just the general information, personal information that's provided by interaction versus the information that somebody may be willing to give up some rights with respect to in exchange for some sort of compensation or value.
Right. It's very interesting. So one of the challenges that organizations are going to have is you got to be able to track all this stuff. That means you got to go build systems. One of the other distinctions in this law is there's an opt-out for adults, but there's an opt-in for minors. And unlike COPPA and the California Child Protection Act, the ages in all these laws change. So in this particular law, it's 16. So if you're collecting data on anybody 16 or under, then it's opt-in on the data collection. So think about the systems and make sure that you can prove your compliance here. Dan?
Nothing further, but if we go to the next slide. So again, one of the areas that's unclear is how are you supposed to interact with other parties? The law does have some provisions on that. We have touched upon that. That's either going to need to be clarified in some form or fashion. But I do believe that in terms of your relationships with third-party vendors that are interacting with the data that you collect, some of the disciplines that we're seeing coming out of the GDPR, some of the discipline that we're seeing coming out of the security side in terms of clarifying with service providers, clarifying with vendors who's got what responsibilities and how are those responsibilities defined, how are they monitored, and what are the remedies for compliance or non-compliance is going to be equally important in terms of complying with this law. The law at present does not require, for example, a particular written contract or form of written contract or contractual language in relationships with vendors or service providers. It doesn't require a formal risk assessment or privacy impact assessment or something like that in terms of relationships with these vendors or service providers. But it does clearly extend the obligations to those service providers. And again, as I mentioned early on in the presentation, it kind of cuts off that or limits that ability to push responsibility, ultimate responsibility, legal responsibility for compliance with the law. It prevents pushing that off on a service provider and essentially washing your hands of that responsibility because you outsourced the function. And in that respect, it is very similar to GDPR, where if you're the controller, you're utilizing processors, that's fine. You've got duties with respect to your allocation of risk and defining and directing those processors. What you don't have is the ability to shift liability onto the processor and absolve yourself from liability because you chose that particular model for a particular part of the processing function. Mitch?
Yeah, I think one of the things that is last bullet here is given the person has the relationship with you, you're likely to get sued no matter what, and you're going to have to go deal with that, even if the vendor is responsible for things.
So is it okay to over-disclose in terms of your notice to consumers, in terms of your communications with, Mitch, appreciate your clarification again, residents? Can we get through this law by simply putting very, very, very broad notices of what we may do and trying to obtain some sort of very broad blanket consents? Probably not. The notices to California residents, the compliance mechanisms that are available and visible to them are going to have to be tailored, and they're going to have to be thoughtful. This is not something where you can just simply say, we may collect your information, we may use it for any purpose we deem fit. Thank you very much. You're going to have to be much more thoughtful and much more nuanced in terms of the disclosures and the notices and the consents with consumers. Mitch? So what happens, what's the penalty for noncompliance? California Attorney General has the ability to bring enforcement actions, $75,000 per violation. That's not globally for all, that's per violation. So and if any of you have ever done that type of an analysis before.
I think that was $7,500 per violation.
I'm sorry, 7,500. And then also on the private right of action side, it's here we're talking class actions, $750 per consumer per incident or actual damages, the greater of the two. Again, any of these privacy statutes, what we see is if there is a violation, it's never a single consumer and a single incident. Because the automated nature of what goes on, it's always a multiple number of consumers and a multiple number of incidents. So that $750, that is frankly probably more than sufficient bait for the plaintiff's class action bar to jump in on this, because I can imagine that $750 being multiplied by 10,000 or 100,000 or more incidents and consumers come up with some very, very large class action damage numbers. So there is both civil penalty per violation, and then there's also this $750 multiplied by 1,000, 10,000, 100,000 in any given case, consequences for noncompliance. There is a cure right built into the statute. How that's going to work in practice is really hard to envision, simply because so many of these types of violations, it's really hard to imagine how you try to put all the worms back in the can. Very difficult, if not impossible to do. Mitch? So as we said before, the law authorizes and in fact compels the Attorney General to adopt regulations to further the purposes of the title. It's going to be interesting to see what comes out of that process. It's not going to be a short process, and apparently it hasn't even really gotten going as yet. But more to come on that front. Stay tuned. And then I think Mitch is going to talk in a minute here about some of the revisions that have already been made and some that are likely. The bottom line is, as Mitch talked about, this law was passed in a hurry, very much in a hurry, and I think that all parties recognized that there may be some revisions. Obviously, the tech industry is lobbying furiously for some relaxation of some of the components of this law. So I don't think we're going to see this law go away in any way, shape, or form, but there will undoubtedly be some revisions.
One of the things that the tech industry is doing is lobbying Congress and the White House to push for federal law, which from their perspective and their hope would be much, much weaker and would preempt state law. So we shall see whether they're successful with that. That's been an effort of the tech industry for almost a decade now to try to get Congress to enact something, and Congress has never been able to pull that off yet.
So the good news, the law is not going to go into effect until January 1 of 2020. We're now in September of 2018, so there's some time. Enforcement doesn't start until 6 months after that. But as any of you who have gone through the GDPR process know, these types of laws require not just the drafting of a couple of policies that go up on a website. There is an awful lot of behind-the-scenes compliance work that needs to be done in order to comply with the law. That work doesn't happen overnight. I think, frankly, most of the people that were GDPR compliant by May 25th, which is the effective date of that law, probably started that process at least a year in advance to try to build robust policies, procedures, compliance mechanisms, data mapping to understand their obligations. If you are already in a relatively comfortable spot on GDPR, then that may ease some of your compliance burden. There are some nuances to this law, but at least you've got some structures in place. If you're not, please don't wait until January 1 of 2020. Please don't wait until January 1 of 2019 to start thinking about this, because there is a long route to building the correct mechanisms to comply. Mitch?
Absolutely. And one other wild card in this is McTaggart's already said that if the legislature lessens this law too much, that he's going to go back and go back to the ballot initiative mechanism. And he's also offered the Attorney General, whom has not either asked for help or accepted it, that he would put together a group of experts to help the Attorney General craft the guidelines that the AG is required to go put together. So really quickly here, there is, because we're running a little low on time, there is a bill on the governor's desk, Senate Bill 1121, which is the first set of what is likely to be a long set of changes. And for the most part, these things are very minor changes, but I'll call out a couple of them. So one is, in the original bill, the Attorney General was a gatekeeper for private right of action, which meant that you had to give the Attorney General the right to sue first. The Attorney General said, I don't want any part of that, and so they pulled that out. So right now, there is no restriction that you have to get the Attorney General's approval before you do have a private right of action. And I believe that's going to turn into a cottage industry for class action attorneys in California. There's a lot of cleanup in terms of things like the HIPAA exemptions, and regarding the language in terms of that $2,500 per violation versus $7,500 violation that the Attorney General had. They deleted the reference to within 1 year of passage for the Attorney General guidelines, and they changed that. It says the enforcement will begin the earlier of 6 months after the publications of guidelines or July 1st, 2020. So that part of that is the box in the AG. But if by some miracle the Attorney General puts out the guidelines, say in September of 2019, then the enforcement could begin earlier than July 1st. So we're assuming that the Attorney General is not going to be an overachiever and get the guidelines out early, but assuming that the Attorney General does, then that could be an earlier enforcement date than July 1st. It clarifies some stuff about personal identifiable information, but what the heck reasonable means, no one knows. It clarifies, although I think it was pretty clear to start with, that the private right of action must be related to a breach that occurred as a result of the failure of reasonable security practices. So we've seen this time and again where people have not implemented reasonable security practices, and I believe that every single breach will be claimed to be the result of that, whether it is or it isn't. It clarifies that the data collected, processed, and sold under certain laws, like the California Privacy Act, the Graham-Leach Bliley, and the Drivers Protection Act, are exempt. It adds an exemption, although there was one already in there, for certain health research. Now it talks about specifically clinical trials. It adds First Protection Amendment protections for non-commercial activities, although I don't believe that California law, and Dan, maybe you can clarify this, as a good way to supersede the First Amendment, but maybe they've come up with a creative way to do that. And
generally not.
And in general talks about the fact that it doesn't supersede the U.S. Constitution. And seriously, it really does say that. So these are pretty minor corrections. It also says that it doesn't supersede local laws until the effective date of this particular law. So these are pretty minor corrections. Assume that there's going to be more next year, and you know, there will be legal challenges. There'll be court cases, but you need to start budgeting. You need to start implementing, as Dan said, and there's a lot of things. You know, Dan was talking about really pushing hard on this vendor data inventory of where your data lives, your vendor cyber risk management program, your incident response program. There's a lot of things that that you need to do now, you can do now, that really will not be impacted. Thinking about what your policies and procedures are, how you're going to train employees, there's a lot of things you can start doing now. So I think we might have a couple of minutes. Ray, do we have any questions that people have submitted?
There was one. Can you give an example of olfactory information? That one has me stumped.
I would speculate. I don't have enough of a insight on all of the various devices and apps and everything that are coming out on a daily basis. But I think if there's one lesson we've learned from the past 10 years is the imagination can run wild as to what types of information may be collected, either through devices, through other Internet of Things issues, or through applications and such. So I'm not aware of a specific application right now. Mitch, you might be, that collects olfactory smell information. But I think that the drafters of this law were probably looking ahead and saying, you know, one thing we've learned is anything is possible. So let's not exclude that in the case that somebody comes up with a new device that manages to harness that particular type of detection or information collection.
Yeah, I don't have a good answer to that, but I think, as Dan said, they're just being cautious. You know, I think the important thing here at this point is, you know, we just kind of touched on this, and we recommend that people reach out to Armstrong, Teasdale, or CyberCecurity. You know, as you think about how you're going to implement this, depending on whether you have, you know, legal questions or technical questions, you know, feel free to reach out to us. We will make a copy of the webinar available, and copy of the slides available if anybody wants those. So I'm going to see if I can roll back real quick to the first slide, which has our phone numbers on it. And so please do that.
While you're doing that, there was one more that came in at the end. Someone was asking for the definition for some acronyms used in one of the last slides: VCRM, IR, VDI. Those three were used. If you could go over what those stand for again, please.
VDI stands for vendor data inventory. That's the thing that Dan was talking about in terms of knowing where your data is, how it's collected, who's collecting it, where it's stored. VCRM, vendor cyber risk management. And I make a distinction when we talk about VCRM from vendor risk management. Vendor risk management, for the most part, is a compliance related activity. Is the organization licensed in the particular state to do business? Do they have the insurance that's required? You know, are any of the principals of the organization on a barred list like that Treasury maintains, like OFAC, if you're in a regulated industry? That's what vendor risk management means to most organizations. Vendor cyber risk management means, let's go look at the cybersecurity principles and practices of that organization. It's a very different process. And I will point out that more than likely, the people inside your organization who are doing vendor risk management do not have the necessary skills to do vendor cyber risk management. The last one, IR, is incident response. Really, really critical. Dan touched on this, that you don't want to be trying to figure this out in the middle of an event. You want to have that well documented. You want to have the team members identified. You want to have people trained, and you want to practice. Dan, any thoughts on that? And then wrap up, please, because we're, I think, at the end of our time.
Yeah, having handled probably over 200 data breach type incidents, I can tell you I cannot overemphasize the importance of an incident response plan, an incident response planning, an incident response training, tabletopping, wargaming prior to an incident. It makes a massive amount of difference in terms of the quality and the ability and the lessening of the challenges in actually responding to an incident. There is a night and day difference. You can respond to an incident either way, but if you have a pre-positioned plan and some training on that plan, it makes things so much smoother. I can't overemphasize that enough.
Absolutely, a perfect poster child of that is Equifax. I mean, as a one minor example, when they were reaching out on social media to people about finding out about whether they were affected, they sent them to the wrong website. Perfect example of what happens when you don't have a plan. So with that, I think we're going to wrap up. As I said, huge amount of information. Please reach out to us. I do have a blog and a newsletter. If people are interested in getting on that list, please reach out to me. We'll be happy to add you to that list. And with that, thank you for your time today. Thank you for your interest in this particular piece of legislation. And I'm sure we'll be talking to some of you soon.
Thank you so much.